in this video, we're going to discuss fundamental rights. This is lesson 2. I have already uploaded one uh, more video relating to the preamble of the Constitution of India, where I have explained what preamble is and what are the important case law that you can add relating to a preamble, and can preamble be amended or not, and what is the basic structure doctrine. So for this video, you can check it YouTube comment section, and also there is a playlist for this because this is a complete series of the constitutional law. So this is the second video of the series, so that is fundamental rights. So let's begin. So what is the utility of this video? This video will be useful for LLB student, for those who are giving judiciary. Especially I have covered what you need to write for mains perspective, for UGC net, because this will give you a conceptual clarity, and for other exams. Now this is a brief intro about myself. Now let's start with the fundamental rights, the background of the fundamental rights. So basically, what is the background of fundamental right? The background of fundamental right is there in UDHR. What is UDHR? With UDHR is the Universal Declaration of Human Rights. UDHR, there are two kinds of rights. The first one is first generational rights, that is civil and political rights. The second one is second generational rights, that is economic, social and cultural rights. It was enacted in the year, actually not enacted, but it was adopted in the year 1948, 10th December 1948. So whatever human rights are provided under UDHR, fundamental rights are also human rights. Whatever human rights provided under UDHR are, that finds that fundamental rights takes inspiration from the rights provided under Universal Declaration of Human Rights, that is adopted by General Assembly, UN General Assembly. And also it has its origin in all Bill of Rights of Man in France, in England, and also in United States of America. And apart from this, fundamental rights has its origin in the Choras Bill. Choras Bill is also known as the Constitution of India Bill, that was made in the year 1895. You can add this point as intro for attempting any kind of questions for judiciary mains or for any exam. You just give 2 or 3 line intro. Okay, why 2 or 3 line? Don't go beyond that because it will be a waste of time. How can you start an intro? You can give the background in the intro, or you can give the quotation in the intro, or you can start the intro through a philosophical angle. That will give a good thing, because your introduction is your first impression what you are going to write. That's why it is important. Let's come to the part 3 of the Constitution of India. So part 3 of the Constitution of India, Article 12 to Article 35 deals with fundamental rights. Fundamental rights are very fundamental for fundamental rights are the basic rights, the basic right that every person possesses, irrespective of any qualifications. That means to avail the fundamental rights, a person need not have any kind of qualification, any kind of conditions, or anything of that like nature. These are inherent rights. That is, if I am born into this world, I am entitled to fundamental rights without discrimination and distinction as to race, culture, religion, or anything of that like. I am entitled to those human rights. Those are very basic for a human being to live with dignity, and dignity is very important term. Now comes, as we know, there is a maxim, ubi just ibi remedium. Where there is a right, there is a remedy. So what is the solution for the remedy? Having substantive rights are not enough. Just like we have IPC, we have BNS. Having IPC or BNS is not enough. We need the machinery for enforcement of those rights. For the solution for this, the solution is provided under, that means procedures, step-by-step procedures, or machinery for implementation of substantive rights are provided under CRPC or under BNSS. So similarly, for the enforcement of fundamental rights, the remedy is provided under Article 32 and Article 226 of the Constitution of India. What is provided under Article 32? Under Article 32, one can move to Supreme Court. One can move to SC, that is Supreme Court, for enforcement of the fundamental rights. The Supreme Court can give what writs? Can give orders, three things: orders, directions, and writs. What are the writs? Writs, there are 5 kinds of writs. rich in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari for the enforcement of fundamental rights. In case of their violation, we can move to Supreme Court under Article 32 of the Constitution of India. Apart from moving to the Supreme Court, we can also move to the High Court under Article 226 of the Constitution of India. Here, an interesting thing: the powers under Supreme Court is narrower than the powers given under High Court. Powers given to High Court under 226 of the Constitution of India. Why the powers of given to the Supreme Court is narrower? Because Article 32 itself is a fundamental right, and there only for the enforcement of fundamental right we can move under Article 32. But for the enforcement of fundamental right and also for any other purposes. Now here the word is any other purpose, which is important. We can move to High Court under Article 226 of the Constitution of India. Now, what are the fundamental rights? There are 6 fundamental rights. The first one is right to equality. Article 14 is the foundation of equality. Now, there's one important thing. Article 14 provides the right to equality. There are 2 terms that is provided under Article 14: equality before law and equal protection of all laws. And Article 14 is applicable to all persons, irrespective of whoever, citizens or non-citizens. Whether he is citizen or non-citizen, it is applicable to both citizens and non-citizens. Now, equality is a concept which is, we cannot, there is a thing called, there are certain exceptions to equality are also there. So, and apart from this, there are Article 15 of the Constitution of India that is more specific than Article 14, that is relating to no discrimination on grounds of religion, race, caste, sex, and place of birth. There is a movie on Article 15 of the Constitution of India as well. And when Article 15 is little more specific, Article 16 goes into more, it is more specific than Article 15 and 14. That is relating to equality of employment, equality of opportunity and employment. Then Article 17 and 8 is relating to prohibition of untouchability and abolition of title. Then comes right to freedom. Article 19 to 22 is there. Article 21 is important. Article 19A is relating to freedom of speech and expression. Under freedom of speech and expression, there are freedom of press. There are freedom to form assembly, union, and associations. Freedom to move freely throughout the territory of India, and many other freedom provided in the Article 19 of the Constitution of India. Article 21 is important. That is relating to right to life and liberty. Right to life and liberty, Article 21 provides that no person shall be deprived of his right to life and liberty except according to procedure established by law. There is an important case under Article 21, that is the Maneka Gandhi case. Then comes Article 23 to 24, that is right against exploitation. That is also important. That Article 23 to 24 is important because it is relating to slavery, servitude, and forced labor. Slavery, servitude, and forced labor is provided under BNS as well. That is old IPC. Then comes right to freedom of religion. In preamble, we find the word secularism. India follows the positive model of secularism. It is different from USA, where the negative idea of secularism has been followed. Now, India, secularism means respecting and developing understanding towards different religion. So this is what the concept of secularism. And Article 25 and 28 deals with right to freedom of religion. Then comes cultural and educational rights. This is the rights of minorities. And then right to constitutional remedies, as I have already explained, that is Article 32 of the Constitution of India. For the enforcement of fundamental right, we have Article 32 of the Constitution of India. Then comes what happens to fundamental rights during the time of emergency. Definitely suspension. Now, Article 358 provides that there are 6 fundamental rights that is provided in the Article 19 of the Constitution of India gets automatically. Now, the word automatically is important. For this, the proclamation of president is not important. Automatically suspended under Article 358. On what grounds it can be suspended? There are 2 kinds of emergency. One is internal emergency and there is external emergency. War, external aggression, or external emergency. Armed rebellion is internal emergency. Emergency can be declared on 3 grounds: war, external aggression, and armed rebellion. If the emergency is declared on war and external aggression, then the rights provided under Article 19 of the Constitution of India gets automatically suspended. Now, under Article 359, the right to enforce fundamental rights. As I have already said, having rights are not enough. For this, we need to have an enforcement of those rights. For enforcement, Article 32 is there. Article 32 itself is a fundamental right, and right to move in any court. And during the proclamation of emergency, the same rights of enforcement get suspended under Article 359 of the Constitution of India, except Article 20 and Article 21 of the Constitution of India. Now there are constitutional amendments are also there. Amendments are important because law is dynamic, law is not static, and law need to meet the changing demands of the society. Now what Constitutional 44th Amendment Act made changes to the provision. The first one is, as I have already mentioned, there are three grounds of emergency: war, external aggression, and armed rebellion. So there are two grounds on which Article 19 can be suspended. If the emergency is declared on war and external aggression, then Article 19 can be suspended. And also, only laws and executive action relating to emergency are protected from judicial review. So executive actions, whatever executive actions the government will take, all the executive actions are protected from judicial review. What is judicial review? The power of judiciary to declare any legislative act, any action of the legislative and executive as ultra virus. What is ultra virus? Something that is beyond the power of the Constitution. Why judiciary will declare so? Because judiciary is considered the guardian of Constitution of India, protector of people's rights. And judiciary is, what is the main function of judiciary? To interpret the death letter of the statutes. So if the judiciary finds that action of the legislative, that is lawmaking body, or the decisions of the executive are not inconsistent with the powers of the Constitution of India, that means they are ultra virus, beyond the powers of the Constitution, then judiciary can declare such acts as ultra virus. But in case of emergency, what happens? The executive actions are protected from judicial review. And also, there is a case relating to Keshavanda Bharati versus State of Kerala, in which it is said that the fundamental rights cannot be amended by Parliament because the fundamental rights are basic structure. Keshavanda Bharati case is important because it laid down the basic structure doctrine of the Constitution of India, and fundamental rights cannot be amended so as to violate people's rights. These are very basic structure of the Constitution of India, because under Article 368 of the Constitution of India, the Parliament has the power to amend the Constitution. Constitution has already been made by the Constituent Assembly. B.R. Ambedkar was the chairman. Rajendra Prasad was the president. That is a different thing. India got independence in 1948. That is the different thing. But Constitution is not giving all the thing. Constitution is definitely world's lengthiest constitution, but then we need certain statutory laws as well. That means laws made by the Parliament, because Constitution itself is not sufficient. Of course, the Parliament derives the power from the Constitution because we have a constitutional supremacy. Constitution is supreme. Parliament is not supreme. It's not parliamentary sovereignty, but it's constitutional supremacy. But then the Parliament also got some power to amend the Constitution. But what is the limitation of powers of the Parliament? Do Parliament exercise the unlimited powers of amending the Constitution as Parliament wishes? The answer is no. Parliament do not have the unlimited power to amend the Constitution of India. The power of Parliament is limited and subject to the basic structure doctrine. Basic structure doctrine means the words that is given in the preamble of the Constitution of India are the basic structure. These are very basic, and these cannot be amended even under Article 360 of the Constitution of India. That's why Keshavanda Bharati versus State of Kerala case is very much important, and there were 13 bench judges in this case. And 13 bench judges means largest bench of the Supreme Court, and that is one of the prelims question. That is important, note down it. In the Delhi Judicial Service also this question had been asked. Now comes FIR and the response of judiciary. There is a case relating to Maneka Gandhi versus Union of India, in which it says that if there are any kind of violation under Article 20 of the Constitution of India, then the same can be tested under Article 14 and 19 of the Constitution of India, and they are not mutually exclusive. So Article 29 held that no person can be deprived of his right to life and liberty except according to procedure established by law. And in case of Maneka Gandhi versus Union of India, it has been held that the procedure should be just, fair and reasonable. Having procedure is not enough, but the procedure should be just, fair and reasonable. And the seizing of the passport of the Maneka Gandhi by the passport authorities are illegal. So this was held in the Maneka Gandhi versus Union of India. This is the judgment of the case. When it comes to writing the case, how will write? First of all, you have to write the fact of the case, then issues of the case, then you have to write judgment, and then rationale of the judgment. What are the rationale of the judgment? This is the format of writing a case law. Why attempting means write a case law in that way? Because that will give a good presentation, and presentation is important. If you want to know more about exams, more about judiciary exams, or more about how to prepare for UGC net, because I have already cleared net and JRF. So and also you want some guidance for LLB also, then please subscribe to my channel. This is all for today. I'll be coming up with a next series relating to our fundamental rights, that is article 12 of the Constitution of India. In the next video we'll discuss article 12. So this is all for today. Thank you, thanks for watching, and if you need the PPT, then you can comment below. I'll give you the PPT link as well. Thank you, thanks for watching.